Hi, I'm Roger Morgan. I'm an attorney in Mountain Home, Arkansas, and I've been practicing with the law firm of Johnson, Sanders & Morgan since 1985. Over the past 40 years, one of the most common issues that our firm sees are probate and estate planning issues. First of all, I would encourage you that if you do not have a will, to contact an attorney and consider getting a will made. That is a very important thing that everyone should have. But secondly, I would also counsel you that you might want to look at the possibility of obtaining a living trust, which will avoid probate. Any attorney that deals in estate and probate matters can help you to determine whether you need a will or a trust. One of the advantages of a trust is that it avoids probate. In Arkansas, probate is a 6-month-long process with costs that run in the neighborhood of 3 to 4% of your estate's value. While you may hear horror stories about the probate process, in all likelihood, the probate of your will for your children will not be all that difficult. However, once again, you might want to consider avoiding probate by setting up a trust that will eliminate the 6-month period and the cost associated with probate. Probate also has a very interesting effect on real estate. While you are in probate, your estate can sell your real estate, but most of the time, unless your will is written a specific way, they still have to obtain approval from the probate court in the county in which the real estate is situated. Once again, you should be aware of this and should be aware of the fact that your property may be subject to probate in determining how best to address your estate planning needs. Another probate issue that we see very common in this area is that someone will pass away here, but they own property in another state. For instance, you may have moved here from Illinois, Iowa, California, or any of the other states in the United States. You buy a house here, but yet you've not sold your property in any of the other states. When you pass away, in addition to probating the real estate that you own in Arkansas, you also will have to go through a probate proceeding in the state where the other real estate is situated. So in addition to the probate proceeding in Arkansas, you also have to go through what's called an ancillary probate in the state where the other property is situated. That adds time and money to the probate procedure, and again is a good reason to do some estate planning and look at if there are some ways to avoid probate when it comes to the property that you own either in Arkansas or in another state. Another issue that you run into when you sell property through a probate is that it's possible that all of the heirs cannot be found. This is more common when you have a situation where the decedent did not have a will. In that situation, the law determines who the heirs are, and it's very difficult sometimes to find all the heirs. The most important thing to do, first of all, like I've said, is to make a will where these people are clearly named and it's clear how to locate your beneficiaries. Secondly, whether you have a will or a trust, it's also a good idea to provide names, telephone numbers, and addresses of all of your beneficiaries, because if you don't know or we cannot find the location of the heirs or beneficiaries, that delays the probate process and also can throw a kink into trying to sell the property that you own here. It can delay closing, or in some events, it can even cause a sale to fall through because the people cannot be contacted. So what I would again encourage you to do, don't pass away without a will. Either have a will, a trust, or some sort of estate planning document, and make sure that you leave a paper trail so that people know the names and addresses and telephone numbers of who your heirs and beneficiaries might be. In very limited circumstances, someone could pass away without a will and with no heirs. Under those circumstances, that property goes back to the state of Arkansas and is eventually sold by the state of Arkansas and put into the general revenues of the state of Arkansas. Again, let me emphasize to you, The way to avoid this is by having a will or a trust. If you pass away without a will and without a trust and you have no heirs at law, then all of your property will go to the state of Arkansas and the state will dispose of it, and it misses out going to your heirs or whoever you would want it to go to. For instance, even if you don't have any heirs, you might want to leave it to a charitable organization or some organization other than a governmental entity. So I couldn't emphasize enough the need to do some estate planning regardless of the size that your estate may be. If you should have any more questions regarding estate planning or the probate process, please do not hesitate to contact me at 870-425-2126 or please visit our website at johnsonsandersmorgan.com.